in the appeal, Block Advertising Limited, MWB Exchange.
Yes, Sister.
May it please your ladyship, your lordships, I appear on behalf of the appellant together with Miss Sally Blackmore and Mr. Michael Paget and Ms. Zoe Whittington appear for the respondent. My lady, my lords, of the 2 points in this appeal, the 2 sections as it were, the anti-oral variation clause section went first in the Court of Appeal. It goes first in the parties' statements of case, and unless otherwise directed, I've proposed to start there as well.
Well, you take your own course, but it sounds sensible.
I'm grateful. Now, in relation to the clause that we're concerned with, and indeed the findings of the trial judge, those appear in rather succinct form at paragraph 21 of his judgment, which I think is in the core bundle at tab 8, page 135, which is the same in the electronic copies. Now, I take you there not least because it is actually quite hard to read the copy of the license agreement in your bundles, but I don't think we will at any stage need to go beyond anything other than the recitation of those clauses. But if one looks at paragraph 21 of the judgment, one sees there what I would submit the learned trial judge found to be a commonplace and an innocuous anti-oral variation clause. And of course, he found that its effect was to preclude a subsequent oral variation, which he found as a question of fact that the parties had made. Now, one only needs to read paragraph 21 before one then turns to see how that paragraph was treated in the courts above. Now, my lady, my lords, I'm conscious that in relation to this issue, there is no precedent that is binding upon you. The issue has not been before this court and was not before the House of Lords. But I hope you will forgive me if I go through the previous decisions of the Court of Appeal, because I think they do help when one comes to look at the wider issues of principle and of policy. Because I would respectfully suggest that this is a point that ultimately will be decided by this court on principle and on policy. But it is, in my submission, instructive to look at the way the courts below approach the matter. Now, in regard to my our statement of case, it's paragraphs 1 to 7 and 13 to 45 where I address these issues. And I hope to follow that, but I hope you'll also forgive me if I stray a little. So that's at tab 5 of the core bundle.
Well, you can assume that at a very minimum we have read both parties' written cases, and we prefer you to stray rather than actually go through them. Because you can assume we've read them. You can also assume we've read the judgments in the courts below.
I'm grateful, my lady. my lady, my lords, in relation to what the Court of Appeal did, and this is where I address paragraphs 1 to 6 of my statement of case, but if I stray a little or I just speak to the issues, I think there's 3 observations I would like to make. Is that what you have as a result of the Court of Appeal's decision is obviously a striking down, perhaps putting it too highly, but a finding that no anti-oral variation clause is ever going to have effect. So it can only have an evidential effect. So it's not just to our clause. It is of the widest possible application. So an anti-oral variation clause will not take effect other than insofar as it has evidential value to show whether or not an agreement was made. Now, if I can accept the invitation and digress a little, with regard to the evidential value of it, I think it was Lady Justice Gloucester who indicated that, of course, the question of whether there has been an oral variation is always to be decided on the balance of probabilities. So the extent to which even on an evidential basis, an anti-oral variation clause has any real benefit is quite limited. Its value can only be to preclude an intention to contract that might otherwise be there. And in that regard, it is also to be observed, and this is paragraph 16 of our statement of case, that it is a first instance decision as well, but in the case of ZVI construction, it was held that where one finds there has been an oral variation, you don't need to go on to find that the parties address their minds as to the existence of an anti-oral variation clause. So the only factual inquiry is, did the parties orally agree in this case? And of course, in the related case of Globe Motors, the question was, did they agree by their conduct? But it is that very limited role that is now given to anti-oral variation clauses. So I made that observation before turning to look at the cases. The other observations I'd like to make is that and I hope you will again forgive me, but although this is an appeal against the judgments in MWB in this case, it is in truth really an examination of the judgments given in the Globe Motors case. Because when we turn to look at the judgment of Lord Justice Kitchin, he firmly adopts those judgments. So I will, in a sense, be seeking to unpick those judgments as well as the judgments in this case. So those are the points I'd like to make as an observation before then turning to look at what I call the pre-2016 authorities. Now, those are the cases of United Bank and Asif and World Online that were, of course, considered at some length in Globe Motors. And I think if one looks at United Bank, I think that's in the authorities bundle, tab 11, and I think it starts at page 168 for those working from paper and 376 for those working from the electronic copies. Sorry? 164 and 371, I'm told. Sorry. Now, this case was, I think, the dismissal of an appeal against summary judgment. The parts of the judgment of Lord Justice Thorpe that one needs to consider are just at page 168, paragraph 17, and 169, paragraph 23. And what I submit the decision is a ringing endorsement, as it were, for the effectiveness of anti-oral variation clauses. It also has a curious feature that it's an adoption of the remarks that Lord Justice Sedley made when refusing to put it on paper. But in terms of how to approach it, it couldn't be clearer or firmer in saying that these clauses are effective. Now, that then moves us to the second pre-2016 case, which was the World Online case, which I think is at tab 13 of the bundle, page 198, which is at page 403 of those working for the electronic copies. Now, again, this was a summary judgment application. And perhaps if I can make another observation here, which is that anti-oral variation clauses are, of course, very much concerned with summary judgments. Because when we come to look at the policy reasons behind them, there's a clear judicial acknowledgement that their role is there, amongst other things, to enable you to avoid the factual inquiry as to whether there had been an oral variation.
Well, they're designed by a creditor to prevent the classic Order 14 defence of the bank manager smiled and said, I needn't worry, it would never be enforced variety, which one sees so often. But it also has another purpose, doesn't it? That even if one isn't concerned with that kind of problem, this case illustrates the value of insisting on a form of variation which is clear the parties don't know and aren't agreed on what was agreed. And that is another value of having these clauses, I would have thought.
Yes, and particularly in large organisations, local authorities, the type situations. Could I also say, in response to that, if I can just pick up on the situations on the bank manager scenario, I'm sure this court is all too familiar with the other forms of defences, relief that can be claimed in relation to conduct surrounding, for instance, financial instruments. If the law stands as it does, of course, the question is, has there been an oral variation? One wouldn't need to go on to look, for instance, at questions of undue influence. One wouldn't need to look at questions of misrepresentation. It would effectively, in many cases, render utterly odious large parts of the jurisprudence, which is usually relied upon, for instance, to defend banks' claims, because you would simply argue that there had been an agreement to vary the written terms. And of course, to go back to my Lord Sumption's observation, that argument necessitates a trial because it is on a balance of probabilities, and the only way out in the instance of the bank is to prove that the oral variation was not made. So, my lords, these cases are about summary judgments, and I believe I'd taken you to tab 13 of the first bundle of authorities on page 193 or 403 of the electronic copies. This is a case where, in relation to the points which we should consider in my submission, really we begin at paragraph 11, page 196, or page 406. One can see just above that the clause which bears a great deal of similarity to the clause in this case. And what one looks at in my submission, because now it is Lord Justice Sedley sitting in court rather than having made a decision on paper, the reasons why he refuses to, in effect, grant summary judgment on the anti-oral variation clause. And what I seek to draw your lordship's and ladyship's attention to is that he says at paragraph 12 that the law on the topic is not settled. At paragraph 13, he refers to the fact that there is a claim in estoppel, and at paragraph 14, he finds that, of course, there is also a set-off. Now, it is our submission that on the ordinary reading of that judgment, all Lord Justice Sedley has found is that the question as to whether an anti-oral variation clause is effective is open to debate. It is a point that can go on to trial. One could question whether he would have reached that conclusion without the other two factors, but that is all he does. He does not find that anti-oral variation clauses are not effective. And if one looks at the judgment of Lord Justice Sheeman, a short judgment, you see an acknowledgement of the force of the submissions. This is, I think, the last sentence. I see a good deal of force in that submission, which is the submission of the appellant, the party seeking to enforce the anti-oral variation clause. So, on the law as it stood before Globe Motors, I submit it is clear that you had one Court of Appeal decision saying they were effective without a shadow of a doubt, and another Court of Appeal saying, well, it's open to debate. It is an issue fit to go to trial. Now, that being so, one then turns to the case of Globe Motors, because, of course, what happened in our case...
Forgive me, do we know what happened in World Online?
We do, or I can assist. We have a copy if you'd like to see. In the way cases change, by the date of the trial, the appellant was arguing that the variation had compromised a claim for damages that was being made by the respondent on the appeal. And as I recall the judgment, I think it's Mr. Justice Steele, he found that the oral variation had compromised a part of the claim, of the counterclaim. So the case had radically altered. And certainly there was no consideration of the issue in the way that it was considered by the Court of Appeal. So in one sense, Lord Justice Sedley had some foresight in that when it got to trial, there were an awful lot of issues that weren't apparent, or hadn't been apparent on the summary judgment, but changed the whole case, because the appellant lost, and they were, as I say, arguing to uphold the variation to limit the scale of their losses. So, Amelia, I hope that's helpful. We have a copy if you would like to see it, but it doesn't follow. The debate gets lost by the time you go to trial. So, if I might then take you to tab 3 in the first bundle of authorities, at page 62 or page 257 if one's looking at it on an electronic copy. Now, this case, as I know your ladyship, your lordships will know, the issue of anti or variation clauses was obiter to the decision that was made, because the decision that was made was decided on point 1 of 6 points, and that was as to the construction of the relevant clause. Now, I hope I summarised the case fairly. That what the case was about was that the one party had been purchasing motor engines not from the other party, but from another manufacturer. And the allegation was that that was in breach of the agreement. They should have been buying all their engines from the claimant. I think it was the claimant. And in fact, they've been buying engines from another company. The decision on which the appeal was allowed was that, in fact, the clause of the contract did not cover the engines which were being bought from another manufacturer because they were different engines. So you'd had this question as to whether one engine was the same as another engine and whether it had intended to apply. And that's relevant because you'll see when one goes to the main lead judgment of Lord Justice Beatson that he looks at this question that when you have what he called long-term contracts, as to the extent to which you define what is meant at the date the contract was made. So here, they defined the engines that were to be exclusively bought from the claimant. Subsequently, a different engine had come along, and the question was whether it could be extended over. It's found that it couldn't. The point which concerns us was the fact that the claim was being brought not by the signatory to the written contract, by another company within the group. And the argument was that the contract had in effect been novated to that other company. Now, that argument was made on the basis of a long period of trading between the two parties. What doesn't appear to have been argued, so far as I can see, is an argument based on estoppel, and in particular estoppel by convention. So the way the case was being put by the claimant was that there was a variation by conduct to the new company, so the new company can enforce. Now, of course, as I've already indicated, because in the way of things, the appeal succeeded on point 1, namely that the engines that had been bought weren't the engines covered by the exclusivity clause. It rendered point 6 obiter, and one can't help but feeling a little bit otio so far as counsel for the appellant was concerned, because he'd won. What there wasn't in the case, though, was any real consideration of the role of equity should play in these types of situations. What also does not seem to have been considered, but does seem to me to be of some relevance, or was of relevance to that case, was that in that instance, this wasn't actually an argument between the two original contracting parties. because, of course, the new company had not signed the anti-oral variation clause. And because it was a case where the variation was said to have occurred by conduct, it also has, when one looks at it in terms of novation and estoppel by convention, one can readily see a different basis, an equitable basis for deciding the case, because certainly on the facts of this case, and I would respectfully suggest that in most cases where a novation is said to have occurred by conduct, there will usually have been a course of dealing out of which it is said that the novation has occurred. So it won't be the fact that you've dealt with the party once that will lead to the implication of a new contract or a varied contract with a new party. Now, I set out those distinctions and before I then take you to really where this point comes to be considered, and that is at page 91 of the paper copy and 287 of the electronic copy, where one sees under ground 6 the argument is being advanced by Mr. Downes, Queen's Counsel for the appellant. I won't, unless the court wishes me to, read out, but you will see there that his argument was, you are bound by United Bank and Asif. Having taken your ladyship and your lordship to those two cases, I would submit that that argument was a sound one. When one goes over the page, though, and looks at what I suspect the court may be more troubled by today, or more interested in today, is that at paragraph 97, Lord Justice Beatson records, and that's how it was described by Lord Justice Kitchin in MWB, the policy reasons in favour of anti-oral variation clauses. And I would suggest they mirror the observations of my Lord Sumption as to why one would have them. Now, as your lordships pass on reading the rest of this part of the passages in the judgment, which I know you will, what I would observe is this. One doesn't find, so far as I can see, any policy reason put on the other side to the policy reasons as set out at paragraph 97. The subheading of this part of the judgment is principle and policy. And the nub of the judgment appears at paragraph 100 in my submission, where Lord Justice Beatson in the second sentence begins, the parties have freedom to agree whatever terms they choose to undertake and can do so in a document by word of mouth or by conduct. Now, how I would interpret that judgment and how I would invite you to interpret it is that is the principle on which Lord Justice Beatson arrives at his decision, and that he has found has outweighed the policy reasons as set out, recorded at paragraph 97. Now, what we contend is that when one comes to analyse the principle, it's actually flawed. And that far from advancing freedom of contract, the decision, part of the judgment of Lord Justice Beatson, has reduced it. And I will, if I may, explore that in a little more detail in a moment. But what I would also invite your lordships to contemplate, your ladyship to contemplate, is this, is that even if you find the arguments of principle finely balanced, or there is not a way of drawing out a principle without an inconsistency. The reasons of policy are overwhelmingly on one side. So what we contend is, if principle is, if you'll forgive me, a score draw, then policy is overwhelmingly in our favour. Now, I will look at this again, and other academics whose opinions and thoughts I've gratefully borrowed. What's in summary wrong with the principle is this, is that under the decision in Globe and under MWB, the one thing that parties are never free to agree is an effective anti-oral variation clause. That is something they can never do. These clauses, which I've already described as innocuous and commonplace, will never be effective in the law of England and Wales. And so, if the freedom to orally vary a contract is one that must be preserved, it can only be at the expense of the freedom to contract in the original contract. So, freedom of contract cannot, we contend, be the proper answer to the issue in Globe Motors and the issue in this case. But my lords, my lady, there is also another factor here, which is that under Globe Motors and MWB, the restriction on the power of parties to contract, which is undoubtedly present in relation to anti-oral variation clauses, is one imposed by the courts. It is the courts who are saying, you can't have an effective anti-oral variation clause.
Well, I'm not sure that that's really right, is it? The argument against you is that you can have one, but it's invariably consensually departed from by the parties' subsequent agreement. The real issue is whether it is open to parties to limit their freedom, the freedom that they would otherwise have under the law of contract, to do something in a particular way in future. Can you effectively irrevocably bind yourself at the outset that you will not exercise a freedom that would otherwise vest in you under the general principles of law?
Yes. I mean, and in one sense, contracts, in many instances, that is precisely what they do. I mean, contracts prescribe how parties will behave in relation to their future trading relationships. That's what they do.
Yes, but they do so in a way that's enforceable for as long as the other party wants to hold them to those restraints. Not the distinction between general position, where of course parties constrain their future conduct by contract, and this position, that an oral variation will only be a valid variation if both, or if it's a multi-party contract, I suppose all, the parties to the original agreed constraint agree.
Well, I think if I could, first of all, the parties, by the contract they make, have agreed that they will not do this.
It's both parties, it's not just the one invoking the clause.
Sorry, it's both parties, yes. So that agreement, we say, is the one that the court is enforcing. The oral variation, or the variation by conduct, is an agreement which, pursuant to the authorities, would appear to be one that can occur even without the parties having addressed the fact of the preceding anti-oral variation clause. So if they make a new agreement whose effect is to vary the first contract, then even though they didn't address their minds to the anti-all variation clause, that is what they have done. So in terms of the parties agreeing otherwise, I would submit there's no difference between the way an anti-all variation clause works and any other term of a contract which restricts how parties must behave in relation to each other. It is simply prescribing a course of conduct. It's prescribing their relationship. If I can try to make the point perhaps in a different way, it is clear, I think the decision is Springwell, that parties can agree, as at the date on which they sign a contract, that a set of facts exist, even if they don't. That has always been. And that, as I've understood it, is the effect of an estoppel by contract. You have agreed that certain circumstances do exist at the date of your agreement, so that the ship is in the harbour, even if it isn't. And that is binding. The question which we are then confronted with in this case is, can one do that in respect of future events? And I submit that one can, because that, in a sense, is what contracts are always doing. They're always prescribing your conduct. And in the same way as this court has recently considered the question of penalty clauses, just as parties can agree what the damages will be in the event of default. That is part of their agreement. It doesn't have to be shown to concur with what is the real situation. Here, the parties agree that they will only vary their contract in writing. That is their agreement. Yes, they have restricted their freedoms, but that's their decision. And all the court is doing, when it enforces an anti-all variation clause, is to give effect to that agreement, which precludes them from setting up and proving the all variation. Now, my lords, I submit that that is consistent with freedom of contract. But it is certainly consistent with the notion that if parties must be free to agree what they like, subject to the constraints of other areas of law, then they must be free to be able to agree an effective anti-all variation clause. Under this decision, they are not able to do that. And not only are they not able to do that in the circumstances where there is found to have been an all variation, but they are not able to preclude the unmeritorious raising of an allegation of an all variation to preclude summary judgment. So if one goes back and looks at it in terms of freedom of contract, and I think that's where we began in our statement of case, where the law now stands, parties can have contracted to avoid a situation where an unmeritorious factual allegation of an all variation prevents summary judgment. They can have sat down and said, that's what we want, and yet they can't achieve it. And it may be that your ladyship, your lordships find there are limitations on how far the principle of freedom of contract can get you, so that you have to choose between freedoms. But it seems to me that the arguments in favour of the freedom that we argue for are far more powerful than those that are put on the other side, which are not actually explained in the judgment, and in the judgment in Globe, and not really explained in the judgment in MWB. Because if one steps back from this case for a moment, the trial judge was very clear that there was no inequity on the facts of this case. So, if there's no inequity, why should the courts preclude parties from agreeing an anti-oral variation clause. If there is inequity, then there are equitable remedies. But as each principle must be tested by pushing it to its extreme, the extreme that's been arrived at by the decision of the Court of Appeal in this case and in Globe is, as I've described it, we have described it in our statement of case. You cannot stop, by the terms of your contract, an unmeritorious factual assertion of an oral variation. And that must then take you to trial. So, my lords, that is the real point of principle on it. And as I say, one can argue it around in different ways. But what I do draw your lordship and your ladyship's attention to is that when one goes on to consider the judgment of Lord Justice Beatson, I submit that where he arrives at is, because he goes through World Online and United Bank and Asif and seeks to reconcile them, is that, in effect, they are inconsistent decisions. Putting World Online at its highest, it is inconsistent with United Bank. And I think that's what he addresses at paragraphs 11 to paragraphs 13. Now, whilst that might be found to be a fair assessment of the two decisions, what I submit cannot be a correct assessment is when one goes over to look at the judgment of Lord Justice Underhill, which is at page 293 of the electronic copy and page 97 of the written copy, where at the third sentence he held, although in the end I'm persuaded that the decision of this court in World Online was correct and should be followed for the reasons given by Lord Justice Beatson. And then he expresses the fact that he felt some hesitation. By no stretch of the imagination, I submit, can you say that you were following the decision in World Online when you decide that anti-oral variation clauses are ineffective. So insofar as Lord Justice Underhill felt that it was the decision in World Online that led him to his conclusion, that is flawed. But, my lords, Lord Justice Underhill, having expressed hesitation, also raised the question of what sometimes has been termed the halfway house. Because taking up the policy points, he could see, and I submit it is plain to see, that the extreme position that one has arrived at in Globe Motors is on the face of it unattractive. Now, in that regard, one is reminded that before Globe Motors, one of course had the law of estoppel, and one had the law of waiver, and the distinction between a waiver and a forbearance. In essence, what one required was, in order to give effect to a waiver or to create a waiver, one needed reliance, one needed detriment, one needed to engage the principles of equity in the usual way. Now, what has happened is that in the certainly the majority, but difficult to think of many exceptions, equity will not, as it were, get a look in. Because if you only have to prove the agreement in order to give effect to an oral variation, it's hard to see why defendants would ever go on to look at questions of reliance and detriment and have to prove those more difficult aspects. Because proving the promise and proving your acceptance of the promise is enough for there to be an oral variation. Now, subject to the question of consideration, which we'll come on to, and these two issues are interlinked, but what I submit is clear from Lord Justice Underhill's judgment is that if there is a better way to arrive at this outcome, then that is the route to be preferred. That is the route that he would have preferred. Now, my lords, and as you will have seen in our statement of case, what we are contending, and we draw some support from an article by Professor McKendrick in relation to this, is that actually there is a halfway house. That halfway house is reflected in equity by waiver, by estoppel. And that arrives at an answer which in policy terms is better. It is also, I submit, jurisprudentially better because the courts have always been able to interfere in parties' contracts where the principles of equity are engaged. That has always been the case. And it does so on that basis and not as a result of the parties' oral agreement. It does so because it is inequitable. But my lady, my lordships, before I leave Globe Motors, if I could draw just one other attention to paragraph 119, which is the judgment of Lord Justice Morbick, who, of course, I think gave permission to appeal to the Court of Appeal in this case, is that at that paragraph, he raises in support of the decision what he termed party autonomy. And at this last sentence, he held, if there is an analogy with the position of Parliament, it is in principle that Parliament cannot bind its successors. Now, as the court will have seen, we submit that is a bad point. Clearly, in relation to parliaments, one votes for a parliament in the knowledge that it will sit for a period of time. A new parliament can always undo that was done by a previous parliament.
The same parliament can do so.
It can, but if one takes, for instance, the Fixed Term Parliaments Act, it can prescribe the process by which it's done.
Yes, but it could also repeal that by one vote.
But
6 months into a parliament.
well, but that is still following what the procedure is as set out under the Act. I digress. And
I mean, a better analogy might be the rule that there's no such thing as an implicit repeal pro tanto of the European Communities Act. You've either got to repeal it in terms or it will override any subsequent legislation.
yes, going beyond the extent of my knowledge, but I of course, I see the principle there. But when one looks at a parliament, it can only sit for 5 years. Perhaps if I can go back and look, for instance, the difference between that and a referendum, perhaps one of the problems of a referendum is it is a vote for a decision, whereas a vote for a parliament is always for something which can only sit for a period of time. But, my lords, I'm no doubt out of my depth in relation to those issues, but what I would submit I'm in shallower waters and firmer footing is to say that with a contract, it is not for a fixed period unless it so states. It is intended to bind the parties. That is what it is doing. That is one of the benefits of a contractual relationship. Now, my lords, the reason I've taken you to that passage is when one then turns to look at the decision in MWB, which I think is at tab 6, it is this idea of party autonomy that, yes, so 313 in the electronic copy and 113 on the paper copy.
Sorry, 313.
Oh, sorry, no, 113.
No, that's all right. I'm there.
313 on the
Yeah,
electronic.
that's
I'm
fine.
sorry, my lord.
Yes, thank you.
Now, in relation to the judgment of Lord Justice Kitchen, it is really, I think, at paragraph 34, which is at 124 or 324, that we get to the nub of his decision and the bits which exercise us on this appeal. Now, I will leave you to read through down to paragraph 36, which I think is really the essence of his decision. And that part, those parts of his judgment are, the other Lord Justices agree, Lady Justice Arden and Lord Justice McComb, they agree with those parts of the judgment. They don't add anything further on this part of this issue. My Lords, I ask you to note, because again I submit it is puzzling and simply wrong, that at letter B, Lord Justice Kitchen refers to the fact that he agrees with Lord Justice Beatson that the decision of this court in the World Online case was correct and should be followed for the reasons he gave. Well, we've looked at those parts of the judgment, but I would submit their proper reading is that Lord Justice Sedley found the issue was arguable. He certainly didn't find in favour of striking down anti-oral variation clauses. Indeed, he observed that there was what he called an inconsistency to them. And then, when looking at his reasoning, Lord Justice Kitchen settles upon, which is why I took your ladyship and your lordship to it, the question of party autonomy. And he says he found that the most powerful of the considerations set out in Globe. And that is the point that I've addressed you on in contending that there is an obvious contradiction in that the party autonomy must include the autonomy to agree an effective anti-oral variation clause. But
he's talking about the autonomy which he encapsulates in Judge Cardozo's summary, isn't he? That is the right to unmake what you have previously made, if that's what you want to do.
He does, well, I think he's there, he's referring there to party autonomy as Lord Justice Moore-Bick defined it in Globe. He then goes on to look at the Alfred C. Beattie case.
Well, he says it echoes, Lord Justice Moore-Bick echoes Beattie.
He does. The case of Beattie wasn't cited in the Court of Appeal below. It's a case which has come to, and I will take you to that. But the two observations I would make before one looks at that is that if one looks at Beattie, it is, in my submission, a classic case that could have been decided on estoppel. So that although you have that part of the judgment of Mr. Justice Cardozo, that isn't actually what was necessary to his judgment. And in relation to the New York jurisdiction, since then, the law has been changed by, I think it is the Uniform Commercial Code that applies in America. Now, that is at tab 28 of the Authorities Bundle 2, which is page 609 of those working from an electronic bundle.
So what's the physical numbering again?
I'm so sorry, my lord. The physical number is 391 of Bundle 2 of the Authorities, which is tab 28. So I hope one has at page 392608 under the heading currentness, paragraph number 2, a signed agreement which excludes modifications or rescissions except by a signed writing cannot be otherwise modified or rescinded. but except as between merchants, such a requirement on a form supplied by the merchant must be separately signed by the other party. Now, I will at a later stage come to other codes, and indeed I'll turn to Professor McKendrick's analysis of them and views of them. But in relation, as it were, to the decision in BT, first of all, one has to look at what were the facts, and secondly, one can't help but observe clearly there was felt to be a need to reposition the law as it is now set out in the code, which would align with what we say the law is for the purposes of this appeal. So, having taken you to the code, perhaps the next place for me to go, my lady, my lords, would be then to Alfred C. Beattie. Now, it is a lengthy case, and like so many of these other cases, has lots of other issues in it. So we have included only those extracts relevant to this point. That appears in the authorities bundle at tab 15 at page 224, which is 437 in the electronic version. Now,
trouble is that for all the facts, Mr. Justice Cardozo referred to a previous instalment of this litigation, did he not?
I believe he did, my lord. I'm afraid I've left that in trying to achieve brevity and succinctness.
Yes.
But if one goes to 227, where one sees the passage of the judgment that was cited by Lord Justice Kitchin, which is 441 in the electronic copies, that is the powerful, I think certainly one commentator described it as rhetoric. But if one then moves down that paragraph, one sees actually the facts upon which the decision was based. And one sees that there's a clear instance of reliance and conduct which, under the laws of this country, would be given effect to in estoppel, in my submission. As it indicates, on the faith of the consent, he turned a loan into a purchase. It is too late, years afterwards, for the employer to cancel the consent and insist that the purchase be turned back into a loan. It is again, just like the facts in Globe Motors, course of conduct, clear reliance, obvious detriment. And nobody on our side of the argument is suggesting that an anti-all variation clause prevents a waiver if a waiver is made out in law. In other words, if there has been reliance, if equity can bite. That isn't the issue.
Why isn't it an issue? Because another way of looking at the subsequent agreement is that it may be consensual waiver of the restrictions in the first one. I'm not sure that you can afford, if your case is going to be coherent, to concede that waiver is still available.
I think how it was put, I adopt how it was put, I think, in Globe Motors. It's where it is backed up by conduct that would allow equity to enforce. That, my lords, is the distinction we seek to draw. Where you've had reliance, where an estoppel by convention could apply, then it can be given effect to.
Well, yes, estoppel is one thing, but waiver is another. Estoppel basically arises out of reliance, whereas a waiver is simply the parties not bothering to enforce some provision.
My lord, my understanding has been that one has forbearance and one has waiver. and the distinction between them, the principal distinction, certainly the distinction for this case, is that on a waiver, there are the acts of reliance which prevent one going back, so that there are clear parallels. I will, if I have the opportunity...
You say waiver is estoppel-based?
Yes. And if I have the opportunity, my lords, I believe that Chitty makes a similar observation in relation to that. Because
the language, I think you're saying that whether you call it waiver or estoppel, you're talking about some conduct sufficient to enable equity.
yes,
So it's equity or bust, never mind which side of the law or equity line waiver may come.
yes. and we say, my lords, that that is, in terms of jurisprudence, very clear, because that is not interfering with the freedom of the parties to contract. That has always been the role of equity. We say that in terms of policy, it provides the halfway house that Lord Justice Underhill was searching for in Globe. And if one were to apply that approach to those cases which have gone against us, to Globe, to Alfred C. Beattie, one can see that in those instances there was a basis on which to say the anti-war variation clause does not succeed. The argument in estoppel was not one that was made out, wasn't one that was argued, certainly at any length so far as I can see, in Globe Motors. But in this instance, you have a situation in which a large organisation has contracted on the basis there will be no oral variations to its contract. The judge finds there's an oral variation. There is no reliance and no detriment. And within 2 days, there is if that is the right word, not too pejorative, a reneging on our side, a resigning on our side from that oral variation. As the trial judge found, the respondent had not been prejudiced by our resiling, but under the law as found by the Court of Appeal, we were then bound by the oral variation, and the respondent was not bound by the earlier written contract that it had signed.
Is there authority on entire agreement clauses?
My lords, I did cite them in the Court of Appeal, and I didn't then cite them here. I think Springwell is...
The issue is rather similar, isn't it?
Well, I think if I can speak against myself for a moment, where it bears a similarity is what I've called the contractual estoppel point, which is one agrees a state of affairs. Where there is a distinction is an entire agreement clause is, of course, applying to the situation at the date the parties execute their agreement. So it's dealing what exists then and what has previously existed.
But I mean, the argument against entire agreement clause, I think I'm right in saying that there are decisions in England where they have been applied. The argument against them is, well, it may actually be untrue. There may actually be further matters agreed and intended to be binding. But I think that the position that the courts have arrived at is, well, if the parties have agreed an entire agreement clause, that simply is ineffective.
Yes.
I mean, I don't see that there's necessarily a distinction simply because it's concerned with what the parties are presently agreeing, right or wrong, as opposed to what the parties may agree in future.
Well, my lord, I raise that point because it is a distinction that I see. I would obviously say that there is no distinction.
I mean, are the entire agreement clauses cases in the bundles?
The only case I think is Springwell, and that may be a misrepresentation clause as well.
May I remind you, Mr. Darton, that the Cambridge Law Journal article 2 months ago by Mr. Morgan that we've got at tab 36 in bundle 4 has a lengthy comparison of the non-oral variation clause with entirement agreement clauses starting at 798.
I'm grateful.
Does that refer to any decisions of the courts?
Yes, it does.
Intrapreneur, some recollection,
That rings a bell.
raising the question. Right. Well, if there is any authority other than the ones referred to in this article, which deals with entire agreement clauses, I, for one, would find it helpful simply to be given the references at some stage.
Yes, my lord, we will. So,
You have the electronic number for the Roberts article. For some reason, the electronic bundle isn't working properly, so I can't just click on it.
790, I think.
It's 790.
I'm told 997,
Yes.
999.
That sounds more like it. Yes, thank you.
Morgan is.
Well, my lords, in relation to the authorities, I think I've now come to the end of the trail in terms of where they got us to, where we now are. In our statement of case, I set out and summarised the points. I think it's paragraphs 34 to 45, and if one might just turn back to those. Because seizing on the idea of principle, policy and precedent, which I think was how it was described by Lord Justice Kitchin, I've tried to summarise our points. Now, these are points that I've made largely in oral argument before you, having digressed. But what perhaps I haven't emphasised in relation to principle and ought is that in relation to an anti-oral variation clause, it does just prescribe a method of variation. That is all it does. So it's not precluding it. So if it is a restriction on party autonomy, I submit it's a very modest restriction. And if one tries to look at it perhaps slipping into policy considerations, if there might be mischief in the fact that a party would agree to an oral variation without realising the requirement to put it in writing. So in other words, the other side of it, so that there might be injustice because there was an oral variation and the party seeking to enforce that variation simply overlooked the requirement for writing. So too will you have the situations in which, particularly in large organisations, as recognised, I think at paragraph 97 in Globe, where there has been an oral variation and the party seeking to resile failed to remember the requirement to put it in writing. It can work both ways. Both sides can be caught out by it. But if the court presumes that parties should know the terms of their own agreements, it isn't a very big restriction. If parties have genuinely agreed to vary, then there should be no problem in them recording that in writing. And a party who is seeking to take the benefit of the variation is on notice of that fact by virtue of their original contract. So, my lords, that in a sense slips us on to questions of policy, which is I put in at ground 3, which is page 69 of both the electronic copy. As I say, in my submission, the policy arguments are entirely one way. I've set those out. Indeed, I'm grateful to Mr. Downs, Queen's Counsel, for setting them out in Globe and for Lord Justice Beatson for recording them there. And on the other side, it is difficult to see what those arguments would be. What at page 70, paragraph 41, I have addressed, and if I put it better there in writing than I've put it in all submissions, this question of a halfway house. And what I would seek to draw the court's attention to is the article of Professor McKendrick, who was, of course, referred to by Lord Justice Beatson in Globe, because in I'm sorry, my lords, it's the bundle of authorities, the first bundle, the last tab at tab 18, which is page 261 or page 475.
Electric.
475 electric, my lord.
Thank you.
So. And really, it's under the section at page 481 on the electric copy, my lord, or 4267, my lords, my ladies.
I don't seem to have a tab 18 in my volume 1. Nor is it at the beginning of volume 2.
I think you've got the last page of it.
Have I?
Well, I'm sure his lordship would like all the pages of it, so if we can...
Well, I may... No, what? Oh, I see. Hold it. Yes, okay. What I lack is the tab, but I do have.
You do have
as
the
Lord
document.
Wilson points out. The
Otherwise,
document.
you're welcome to have mine.
No, I'm very happy to use my own.
My lords, unless you feel that the argument of principle is, as it were, so compelling, as outlined in Globe, in other words, the party autonomy point, the freedom to contract point, we are very definitely into the realms of policy. And it's to that end that I've drawn your lordship's attention to this article, and really where it begins in relation to comparative law. Because you'll see there that references are made to various conventions in which the issue is dealt with, and we've addressed them in our skeleton arguments. So, insofar as it is of assistance or relevance, the adoption of anti-all variation clauses is widespread. And in some of the codes where it's been adopted, there has been a recognition of the need for a halfway house. Now, we've included the conventions referred to by Professor McKendrick, because what his conclusion is, when one goes over the page to 482, what I submit his conclusion is that the law of England and Wales should seek to mirror those conventions that provide for what he called an estoppel-type doctrine. Which is, in essence, what I sought to argue for, and particularly in answer to questions as to waiver and as to estoppel. Because it's really the last sentence, the first sentence of the last paragraph. However, there comes a point in time, an exact point in time may be difficult to locate with precision, when the conduct of the parties in reliance upon the non-compliant variation is such that effect should be given to that all variation. My Lords, what is described there, I submit, is exactly the process that Mr. Justice Cardozo went through in Alfred C. Beattie. It is a process that, had it been gone through in Globe Motors, would have arrived at the same result because of that long period of dealing between the parties, because of the obvious reliance of the new company on the contract. But it is completely absent in relation to the facts of this case. Here, the appeal succeeded below simply on the fact of the oral variation. Not reliance, not detriment, but just the fact of the oral variation. And that, I submit, is an extreme position for the law to find itself in. So, I think that's all I want to say on that, isn't it? So, my Lord, if I have missed any points that I make in writing, I obviously ask you to have regard to those. But in relation to this first part of the appeal, those are our submissions. But before I turn to the question of consideration, what I would like to observe, and I'm not sure this is necessarily set out in our written argument, is the interrelationship between consideration and anti-oral variation clauses. Because I submit there are two factors as a consequence of that do need to be considered. The first is that if the law of consideration is now, as it was found to be by the Court of Appeal, then the commercial desire to have an effective anti-oral variation clause becomes all the greater. Because until that decision, save in cases where there was a contract for services and perhaps goods, most variations, certainly variations concerning the payment of money, would fail because of a want of consideration, because of the select move dicta, which we will look at in a moment. Now, they won't fail. So if I'm facing a possession action, if I'm facing a claim for the payment of money, the only assertion that I need to make is that there was an oral variation for a new repayment of terms. Once I make that assertion, put forward some evidence of it, summary judgment is not going to be granted. It's extremely difficult to think it would be granted. So that's the first connection between the two, because this case, in terms of its impact, has to be seen as one. But the second point that I...
Mr. Darton, you've mentioned this question of summary judgment, limited access to it. I mean, it seems to me that whenever a court is invited to discern the law or develop the law, there can be an argument that weak cases will attempt to jump on the bandwagon and won't necessarily be able to be weeded out at first. How strong an argument is that?
Well, as a general argument, was an argument in this case, because I think there are distinctions between different areas of law. What I say this case in the Court of Appeal has done is it has precluded an argument at summary judgment which can dispense with an evidential-based defence of oral variation.
But I mean, it's how can it be objectionable to rule out summary judgment in a case where there's a triable issue? The whole question we're concerned with is whether there is or ought to be a triable issue on this kind of point.
Because the parties have, by the anti-oral variation clause, agreed to such a consequence.
Well, either they've validly done so or not. It can't be an argument one way or the other to say that on one view of the law as we might define it, more people will get leave to defend. They'll get leave to defend because the law gives them an arguable defence. There's no particular virtue in summary judgment, least of all in cases where there's something to argue about.
Well, my lord, the power of parties to agree a contractual term whose effect is to allow one party to obtain summary judgment in circumstances where they otherwise wouldn't, has been recognised.
Well, you're entitled to say that this is a reason why parties might wish to include an NOM clause in their agreement, but it doesn't get us any closer to answering the question whether it's binding.
Well, it goes to the arguments of policy in favour of why it should be binding. But if an entire agreement clause can have the effect which it can, in my submission, of allowing summary judgment to be obtained where it would not otherwise have been, because it excludes a factual inquiry, then by the same extension of principle, an NOM can exclude a factual inquiry as to whether there was an oral variation. The parties' agreement is given effect to on the summary judgment hearing. And that is what is always occurring where you have a entire agreement clause or you have an agreed set of facts clause. The parties are stopped by the terms in their contract from arguing for the true factual reality. And the court gives effect to that by reason of their agreement. Subject, of course, to those instances where statute may intervene to protect the consumer or where equity may intervene because equitable principles are engaged. But that is, in my submission, what the courts regularly do. So, following on from that, that is why I make that submission to say, well, if you see the two together, you have arrived at a very stark position in relation to the law. If the law of consideration was left as we contend it should have been left, then we would have succeeded in this case, but also in a whole load of commercial situations, those in our situation would also have succeeded in the payment of debt situations, in the payment of money situations, because there would not be consideration. So I said I would offer you two factors which I think arise out of the connectivity the interconnection between the two, and that's one of them, that the commercial reasons become greater. The second, though, is that, and I tread carefully because in the list of issues, as it were, the repeal of the requirement for consideration, the removal of the requirement for consideration isn't actually one of the issues, but I've seen it being raised by my learned friend. But in the course of making that argument, you're invited, and indeed Lady Justice Arden made reference in some of her judgments to other jurisdictions where they don't have consideration or in the same way. But I would submit that, and I'm firmly not inviting you to go down this route, that if you do go down the route of looking as to whether you should have consideration in the law of England and Wales, and do so by comparing with other jurisdictions, you need to look at the other contractual requirements that those jurisdictions have. So in other words, I think this is in relation to the American Code, for instance. You may not require consideration in the context of a written contract under one particular jurisdiction, but anti-all variation clauses are effective. So you have to compare like with like. Or perhaps, and now I run on really to the end of what I plan to be the end of my submission, so you can't, when one looks at the law of consideration, see it in isolation. because the law of consideration is about the requirements for a contract that the courts will enforce. And anti-all variation clauses fall within that, in the sense they prevent such a clause. So I make those observations. Now, my lords, in relation to the consideration, that is dealt with at paragraphs 8 to 15 and 46 to 65 of our statement of case. Now, really, if I might speak to our argument rather than going through it first, what our case is this, is that you have consideration. As a consequence of having consideration, there are two points, impediments, call them what you will, that are present. One is the point that was considered in Stilk and Merrick, I think it is, that you can't have consideration to perform an existing contractual obligation. But the second, and although I think Chitty describes it as a mirror image, is that you can't offer, a consideration cannot be the payment of a lesser sum. Now, my lords, I think, and I would suggest that there is a jurisprudential distinction between the two. With regard to the second, which is a sort of Pinnell's case point, is that if consideration must be something of value, because money is a universal currency, it is, its value is certain. The second point, the Pinnell's point, that the payment of a smaller sum in return for a larger sum cannot be good consideration, is an inevitable consequence of having consideration. If consideration must be of value, then you cannot arrive at a situation where arithmetically you can see that it isn't, or it is of lesser value. And the reason why I start there is that, of course, we're going to come on and look at Williams and Roffey, and then in re-select move. One of the criticisms that I think some academic commentators have made of Williams and Roffey is that Pinnell's case, Folkes and Beer weren't cited. But if you accept those two factors, namely that the performance, that consideration cannot be the performance of an existing contractual obligation, and that there's a second point, the arithmetic point, I submit you can see the distinction that clearly exists between the decision in Williams and Roffey and the decision in re-select move. You can distinguish them perfectly. Because in re-select move, one is dealing with what I will term the arithmetic point. Because one is dealing only with the payment of money. And of course, as I'm sure everyone in this court knows, the court is never concerned with the adequacy of consideration. But where one engages the Pinnell's decision, it is because it is solely about money that you can see the disparity. So you can see that it is not of value. And that will always apply where it's a payment of money case, and may not apply where it relates to the provision of services, for instance. So I start there because what I would go on to contend is, and we'll look at Williams and Roffey, is that Williams and Roffey was a decision which was limited to services, and I say possibly goods. If one looks at the judgment as we will of Lord Justice Glidewell, his 5 propositions, and perhaps that's an appropriate place for me to go, is that the authorities bundle tab 12, My Lady, My Lords, at 354 on the electronic copy and 184 on the paper copy.
Sorry, which electronic?
Sorry, my lady. 350. I'm so sorry. It's my writing, my lady. It's not my...
Yes, it's not.
No, Williams and Roffey. I'm told it's 379 And so my electronic reference would be to 394. And on the paper copies, those of us working for those, I think it's 184. Now, in that part of the judgment of Lord Justice Glidewell, he sets out what he himself describes as the 5 propositions that are discernible from previous case law.
Which page?
And what we submitted,
184.
I'm so,
Yeah, 184G.
yes, sorry, I'm so sorry, my lords, 184 to 185. Yes, and if one goes to letters, if one can do it the old-fashioned way, so starting at G on 184, and then going over to C on 185. Well, in fact, we could stop at A, I think, perhaps for that point. But this, in the Court of Appeal, the issue was concerned with what is, in fact, I said there were 5 and there were 6, there we are, my maths in an arithmetic. Sorry, I'm sorry, 6 is right. But if one looks at 4, as a result of giving his promise, B obtains in practice a benefit who obviates a disbenefit. Now, this has since become the practical benefit point. But I draw your lordship's attention to this part of the judgment of Lord Justice Glidewell because he doesn't say that as the only requirement. He, of course, refers at Roman 1, if A has entered into a contract with B to do work for or to supply goods or services to B in return for payment by B. Now, I will have to take you briefly to the facts of the case, but in this case, and I will do so, but we are not engaging the first principle as set out at Roman 1. This is a case that has only ever been about the money. The respondent's obligations were to pay money. The oral variation, as found by the judge, were to pay a sum of money that was owed over a period of time. Therefore, if the Court of Appeal's decision in this case is to stand, it is an extension of Williams and Roffey. It is not the application of this decision. This decision was intended to deal with the provision of services and, if one sees here, also goods.
Is it relevant that it's not a case of a simple debt, but that it arises in the context of a license, where considerations of the continuation of the license may arise?
We say, no, it's not relevant. But if we go to the facts, we will say that actually this suggestion about continuing the license agreement is a misnomer. So where Lady Justice Arden talks about avoiding the void, that was not a finding made by the judge and not a finding, therefore, a basis on which the Court of Appeal could make their decision. So there are 2 answers to your lordship's very proper inquiry. The first I say is no, it doesn't make a difference. That Williams and Roffey is limited to cases where it's a supply of goods and services. And the jurisprudential reason for that is that, and I think it was Lord Justice Russell, as he then was, observed, you could say that the only contractual rights that you enjoy under a contract is a right to sue in the event of breach. You never enjoy a right to enforce. You only ever enjoy the right to recover damages. Now, of course, that has a fair amount of truth in it because, of course, the enforcement is in the courts, and the courts have a discretion. In the context of Williams and Roffey, where, so far as I can ascertain, it was a small subcontractor, the difficulties of enforcement could, one can see, arrive at practical benefit, if practical benefit is a good doctrine. But
the academic criticisms of this are that the extra speed of work wasn't itself a variation of the contractual obligation, so that although there was a practical benefit, there was no contractual benefit. And what the argument is that only contractual benefits can be relevant to consideration.
yes. But there is another argument, if I might, my lord. I obviously adopt that, but there is another way also of looking at it. It's not, we submit we don't need to show that Williams and Roffey was wrongly decided. But if there is a flaw in the reasoning, it is this, that the consideration has to be present as at the date of the variation. The consideration, therefore, can only be the promise to perform. It is not the performance itself. The subcontractor, therefore, made a promise to do that which he had already contracted to do. And the benefit which the main contractor took was in the fact that it had been performed. So you have this problem with practical benefit where it relates to the performance, that one can readily see on the facts that there was a practical benefit to the contractor in Williams and Roffey, but that appears to be being judged as at the date on which the claim was being brought, when the works have been substantially completed.
Well, no, it isn't. It's because what it is doing, it's attaching value to an expectation at the time of the original variation. It's attaching value to it because the person agreeing to pay more for a faster job, albeit that a faster job is the contractual obligation anyway, has a stronger expectation that the obligation will be performed. The question is an expectation which may be entirely reasonable and likely, that makes something, that the more expensive covenant more valuable, is that something that's relevant simply because, in theory, he should have done it anyway if there's no greater likelihood of his actually doing it?
My lord, that is, of course, one of the powerful arguments. But there is also, because the decision in Roffey is looking beyond the contract itself, the contractual benefit. What I'm contending for is that in addition to the point your lordship makes, you can see here that if one looks at it in terms of the promise made, it is harder to discern a practical benefit. Now, I could foresee certain commercial relationships where it might have a benefit. For instance, in public companies, whatever, where an announcement that you will perform could at that moment confer a practical benefit. But to try and deduce a practical benefit from a promise to do that which you've contracted to do is, I submit, when one looks at it in purely legalistic terms, very difficult.
Well, you don't look at it in purely legalistic terms. That's the point of its being a practical benefit. I mean, if you, there is a difference, isn't there, between the original covenant and the new one. The new one is more valuable because the increased remuneration makes it in practice more likely to be performed. Now, the legal nature of the obligations may be exactly the same, but their practical value may be different. And the question is whether, if you have an identical legal obligation, but a more valuable practical prospect of performance, that can constitute consideration.
Yes.
Why not? Why shouldn't it? You're comparing the two, you're looking at the value of the two obligations, and the fact that they're legally the same doesn't mean they have the same value.
I think the answer to that has to come. Firstly, I will address this without going to look at the issue of what I've called the arithmetic point, because I say that sits distinct and separately when one's dealing with money. The next observation that I make is that within your Lordship's hypothesis were a number of necessary assumptions. Stripped down without those assumptions, you have a contractual promise to do something and you have a promise to do something. At law, one would have thought the contractual promise is of greater value. There can be circumstances, as your Lordship has properly pointed out, where the subsequent promise may be of value. But they will be fact-specific. They will depend also on the views of the parties and the circumstances of the parties.
Well, they'll be fact-specific, but, I mean, if people agree to pay more for the same service, they're not likely to do that unless they see some advantage in it. So the specific facts are likely to exist in an extremely high proportion of cases where the question arises.
And if one then follows that through, my Lord, then the consequence of that is that whenever parties have agreed to a variation, one could assume that there is practical benefit. Because from the fact that they have done it, there must be a practical benefit.
No, it's very likely that there will be. Put it higher than that.
How I would, in addressing that issue, how I would respond to that is to say, what is always required is something more than the benefit that one can assume will always be present where there has been a variation. If one doesn't require more, which I think was Lord Justice Peter Gibson's judgment in Select Move, if there isn't something more, then one is effectively doing away with consideration where one has a variation, because assuming that parties, as it's been said and said against us, businessmen know their own businesses, and they will have agreed because they see a benefit in it. What I would contend in relation to Williams and Roffey is when one looks at how the facts were before the Court of Appeal, there was an acknowledgement of a benefit, I think in evidence that had been conceded, practical benefit. The main contractor had been subject to penalty clauses. The main contractor accepted that the job was not going to be performed under the price that had been set. So there was an acknowledgement of practical benefit and an obvious practical benefit. And in the context of a contract, which would have been difficult for the contractor, if not impossible, to have enforced. Now, if I then turn back to your Lordship's earlier question in relation to, as it were, what sort of case this is, because it's a fair one to make, I think it is necessary to, well, one can look at the findings of fact of the judge, but one can actually just look at the way they're summarised helpfully by Lord Justice Kitchin. If one goes to the core bundle, the first core bundle at tab 6, and page 117 on paper and 317. It's paragraph 2, so going through until I think it is 6. Now, if your ladyship would be kind enough just to remind yourself of those paragraphs, what I would submit is clear from them, and these bits we accept as an accurate précis of what the judge found, is that the agreement was to pay off the arrears over a period of time. That period of time actually was within the licence agreement. There is an error in Lady Justice Arden's judgment. The period that is referred to is within the licence agreement. I think perhaps the best way for me to address that, since it may be a matter of significance, is to take you to the judgment below, the trial judge's judgment. Can you find me, please? Because if one turns to paragraph 14 of that, page 133 of both the electronic and the paper bundle, which is tab 8 of the core bundle, one sees what the judge's finding is in relation to what he describes as possible commercial benefit. The agreement.
Sorry, which paragraph are we looking at?
I'm so sorry, my lord. Paragraph 14. 14.
Thank you.
And if one goes back to, one sees it, because it isn't so easy to follow. From paragraph 10, one sees the offers and counter offers. So when one gets to 14, one arrives at what was actually agreed. Now,
you can't put too much weight on possible, I think, Mr. Darton. You won't have forgotten paragraph 20, quote, some commercial attraction, unquote.
my lord, of course I note that and I'm grateful. But the first point I wanted to make is the distinction between what was the consideration. What was being offered was the repayment of the arrears over a period of time. There was no commitment to stay in the premises. There was certainly no commitment to stay beyond the term of the license. And what I submit the learned trial judge is doing there is he's finding that, in effect, because the arrears would be paid off, the tenant would stay in, and that may be of commercial benefit.
What you have to submit is that however clear the practical benefit, practical benefit simply isn't good enough unless the benefit is to be found in some improvement in the contractual terms. Then there's no consideration. That's what you have to submit, surely. So there may not be much value from your point of view in arguing about how strong the benefit is. In principle, you've got to say practical benefit not arising from the terms themselves is not good enough. And one of the problems about that is that the doctrine of consideration is a difficult doctrine, which one certainly wouldn't reinvent as part of English law if starting from scratch. And there isn't an obvious reason why one should take this somewhat unattractive doctrine and give it a larger meaning than is strictly necessary.
Well, I'm certainly not contending to giving it a larger meaning than is necessary. I'm submitting that it is a necessary consequence of having that doctrine. I'm submitting that what was found by the judge is a case that falls firmly within the reselect move dicta, because it is a payment of money. I submit that, firstly, because the judge's findings as to what was offered was to pay the arrears. Secondly, because there was already a contractual obligation to pay for the balance of the license. And thirdly, because unlike the situation in Williams and Roffey, on enforcement, it is a claim for a money judgment whether you sue on the contract or whether you sue on the promise. there is not the difficulty in securing performance that was present in Williams and Roffey. As at the date of this oral variation, we had the right to sue to recover those monies. As a result of the oral variation, we had the right to sue for those monies. The case is clearly distinguishable from circumstances where you are providing services or providing goods where the performance is not something that you can secure other than going to the courts, and you cannot be certain of the outcome of that. That is the way that I draw that distinction, and that's why I say that there is a, together with your Lordship's observation of the overweening principle, there is a distinction here. Because this was just a license agreement to pay, under which the respondent's obligations were to pay money. And the obligation of the tenant was of the licensee was to pay until the end of October of, I think it was 2012. Nothing was changed in that. And that is a distinction from the facts pertaining in a case like Williams and Roffey, where there were findings of fact as to penalty clauses. There was an acknowledgement as to the fact that the promise to perform was of practical benefit. Here, there are no findings to that effect. All there is, in my submission, is the same analysis that was recognised in Reselect Move, where a party offers to pay over a period of time, which in Reselect Move was so firmly found not to be good consideration because of the decision in Pinnell's case, which I submit is firmly based on what I have called the arithmetic test. It is a quantity of money. And as Lady Justice Arden helpfully observed in I can't remember if it was in this case or in Collier, is that to pay later is worth less than to pay now. So it still falls within that arithmetical parameter. That's why, my Lord, I don't just take the bold assertion that, as it were, putting my case at its highest. I say if you look at this case, there is a distinction between cases which will fall within the rubric of Williams and Roffey and cases which fall within Reselect Move. That distinction is based on whether the obligation is one to pay money, and that's all the obligation ever was here. Everything else that's in the judgment are simple surmises as to what might lie behind the reasoning for us to agree those terms. That is not good consideration because of the decision in Reselect Move, because of the decision in Pinnell's case. Now, my Lords, in support, my Lords, perhaps one thing I should do while I'm here, because there is an error for which both sides, I think, take responsibility in relation to the statement of facts and issues, which is that I think we, in a joint statement, stated that the payment schedule could not be found. Well, it has been found.
Which paragraph is that?
Oh, I'm so sorry, my Lord, just give me a moment. I think it's paragraph 6, page 43 of both the electronic and the paper copy.
There it is.
My Lord, I think this has been... I believe it has been sent into the court only yesterday. We're grateful to the respondents for finding it. But if I can indicate this, it shows the payments being discharged as of October of 2012. So in other words, within the license agreement's terms. The license agreement ran from the 1st of November of 2011. And that's why I say, and it may be that Lady Justice Arden was confused but on that issue and would have benefited if she hadn't seen the schedule. But when one sees the schedule, it only goes to October. Now, I correct that, but it doesn't alter what is set out at paragraphs 3 through to 6. And in my submission, it doesn't alter the point that I've made, that you have to distinguish between cases which are about payment of money and cases which are about the provision of services and possibly goods. And to support me in that argument, I rely on a part of the judgment of Lady Justice Arden, who herself acknowledged this distinction in Collier and Pierre M.J. Wright, which is a decision, I think, in the Authorities Bundle 2, at tab 21, page 311 on paper, and page 527 electronically.
Did you say 527?
526, I'm sorry, my lord.
That's right.
It's paragraph 3, and Williams and Roffey appears between D and E.
Yes.
Now, in this case, Lady Justice Arden was exploring the extent to which equity could apply in circumstances where there wasn't consideration at law. This was a case about payment of money under guarantees. I submit that the summary of the effect of Williams and Roffey is as put there by Lady Justice Arden. Does not apply where the debt arises from the provision of services. This is not a case about services. It's not a case about goods.
Why are you blinding us or seeking to blind us from looking at other aspects of possible practical advantage?
Well,
I know you've got this distinction and so forth, but why can't we say the alternative for MWB, instead of accepting the revised schedule, would be to terminate the license and sue ROC? Suing people is expensive. Then you would have had to try and find another licensee. Finding other licensees might be expensive, and so forth and so on. Why can't we do that exercise?
Well, Pinnell's case would fall in my submission if you were to do that. Folkes and Beer would fall if you were to do that. If the law of consideration is to be done away with, and I'm not inviting your lordship to do that for the reasons I've already alluded to, then it should be done by the front door. Abolish consideration. But if one uses practical benefit as a device to bring down what in Williams and Roffey was described as a pillar stone of contract law, I can take your lordships to that judgment, but that's how it was described, then you've done away with it, but you've also created considerable uncertainty. When will the judges find practical consideration? And I remind the court that in Williams and Roffey, the courts were greatly assisted by the fact that there was a concession there was practical benefit. One would end up with a case-by-case basis because there is always some practical benefit. It is something more than that. And that, I submit, was recognised in Williams and Roffey. So I'm not seeking to blind your lordships, and presumptuous for me to even attempt. What I'm submitting is one of clarity. If you won't do away with the law of consideration, as I submit you should not, then there has certain limitations. It brings with it. They are very limited. Two of which are that you can't provide consideration by the performance of an existing contractual obligation, which Williams and Roffey then varied in the case of goods and services. And the other is the arithmetic limitation, that you can't offer a lesser sum as consideration for a greater sum. because that isn't then a value. So, and to look at, because I can see this is where one can then see the argument going, I never get the order right, the horse, the cloak,
The hawk.
yes, thank you. They beautifully avoid the arithmetical problem with consideration. Because the moment you're not dealing with money, then you're not comparing like with like. And that's one reason why that device works. The second reason is that, of course, that where parties use a peppercorn, they are making a conscious decision to get around the rule of consideration. Now, there is more than one explanation for why we have the law of consideration. But one of the suggested reasons is to evidence the intention of the parties to be bound. Now, I'm not suggesting that's the only reason or that over history it hasn't changed. But if the parties specify a peppercorn, then they actually have fulfilled the role of consideration. That is not showing that consideration doesn't work. To the contrary, it is showing precisely why it does work.
Well, you couldn't have a clearer case of the parties intending to be bound than Folks and Beer, where they drew up a very formal agreement.
My lord, yes.
I mean, this is the oddity of the doctrine of consideration. It wasn't good enough. I mean, I think most people in modern business, and possibly most people in 19th century business, wholeheartedly endorse Lord Blackburn's suggestion that everybody knows that a bird in the hand is worth two birds in the bush.
Well, the saying is, of course, in so many situations true, but it isn't the only reason for consideration. But nor do I feel to suggest that this appeal turns upon me satisfying you as to why we should have consideration. There is, I think it is a tier who, I hope your lordships, this is the core bundle 3. As inevitably, and I'm grateful to your lordship's intervention, slip between sort of wider principles and the case. What I would simply like to do is take you to tab 31, which page 499, page 317 of the electronic copy, my lord. My lady.
Sorry, page.
You mean 3?
717, my lord, of the electronic copy.
717.
499 of the paper copy, which should be at core bundle 3.
Mm-hmm. Thanks.
Authorities bundle 3, sorry, my lord.
I've got page 241 of something called consideration or restatement. Is that right?
Yes, that's the text number.
Yep.
Yes, I'm grateful. My lords, it's really beginning. The first is that to talk of abolition of the doctrine of consideration is...
Sorry, who is this? What is this?
This is a tier.
Professor Attier.
In what publication?
Essays on Contract, 1986, my lord.
Thank you.
I think it was cited by the respondents. We've gone simply to the... I anticipated being asked the definition of consideration. And I therefore marked this up, intending to refer your ladyship and your lordships to it. But I think that when one looks at it, one sees that it means a reason for the enforcement of a promise. So it would therefore appear that Professor Attier is taking more than just intention. And I hope I made that clear a few moments ago, that I wasn't arguing that it was only evidence of intention. Obviously, one can look at the history of how the law of consideration evolved, but the point about it is that the role it fulfills in the law of England and Wales as regards contract is it's a reason for the enforcement of a promise, a reason for the recognition of an obligation.
But if the contest is between some different or more valuable contractual performance or some practical benefit, and Professor Attia is right in saying this is all about whether the court should enforce promises. It's a commonplace in modern business, isn't it, that where parties undertake a relationship where one provides some facility or services to the other and the other provides money over a period of time, commercial considerations sometimes lead to the money being either too much because the payer is going to go under if he can't provide it, or too little because the provider is going to go under unless he can get some more. And parties commonly agree to vary their arrangements, often in solemn form if necessary, to accommodate the otherwise disabling effects of those commercial realities. The practical benefit being that the contract can carry on rather than founder. Now, why should we have to go back to peppercorns and hawks to make that enforceable? It seems to me there's a perfectly obvious reason in the modern world why it should be enforceable.
Well, because then one is doing away with consideration. One is saying that it's...
Well, no, I'm just kind of what kind of consideration?
Well, the point is this, surely, that exactly the same promise is not necessarily worth the same in the original agreement as in the revised agreement. Why should we disregard this rather important difference?
The promise at law is the same.
No, the promise is the same, but its value is different. So what you're getting is a new promise, which is legally the same, but is more valuable to you.
Well, I made my point just to the extent to which it will not always be of more value to, and the point in relation to performance. But, my lords, what I am contending for is that in accordance with In Re Select Move, to apply that, one has to have more than the obvious benefit that comes out of restructuring. Because if one doesn't, then one is making a nonsense of consideration. And one shouldn't make a nonsense of it. One should either abolish it, and as Professor Attia says, if you abolish it, then you have to put a new doctrine in its place. And in relation to the way men of business conduct their affairs, they have, of course, for many centuries conducted their affairs against the background of consideration. It is all too frequent to have the existence of peppercorns, and I would contend most men of business are familiar with that. If you are to replace it, then you not only have to come up with a new doctrine, as Professor Attia says, but you also have, in effect, the problems of working that doctrine through. And the doctrine is not particularly onerous. I've highlighted those two instances where it is engaged. The performance of an existing obligation. But the second, the payment of a debt. And the payment of a debt takes us back to Pinnell's case and talks about values. You need something to determine when you will recognize an obligation. And whichever device you use, then it has, as it were, consequences to it. The consequences of consideration are that it has to be something of value. So, my lords, that's what my answer to that. I can't say to you that there is no value when there's a restructuring of an existing debt. There's no value when there's a further promise to pay. But I do say that A, it has to be more than that, because that's what the cases say. B, in the case of money, the position has to be treated differently because of the arithmetical test. The Pinnell's case point. You are comparing like with like. It is money against money. But the third point is you have to look very carefully at the circumstances in which you can say that extra benefit exists. It has to be something more than that which always flows from the restructuring. And I will take your lordship, if I may, to reselect. There definitely was present there in Williams and Roffey. It was present. There were a series of findings. But, my lords, in relation to the case that is before you, I firmly contend there is nothing to consider that. There is no finding that it was of concern to the appellant that the premises should remain empty. And, my lords, if one wants to look at inferences that can be drawn, the fact that we took back the premises on the 30th of March is a strong inference that we weren't concerned about it being empty. In Williams and Roffey, the court found what the parties acknowledged to be practical consideration was good consideration at law. Here you have no such findings. And in the context of a trial where the learned trial judge was not referred to reselect you, he wasn't referred to this distinction where one is dealing only with money. So if you are to apply practical benefit, it has to be in cases where you have made those requisite findings. And I remind your ladyship and your lordship that in this case, the judge talks about the hope, the possibility, there may be some. And how distinct that is from Williams and Roffey. And as I say, if you follow that on logically, then all you end up doing is putting an end to consideration and doing it in a way which just creates considerable uncertainty. My lords, I note the time, and perhaps I should use my time as best I can to take your ladyship to reselect move, which is in the core bundle, tab 5, page 303.
Well, would you say that this case can't be distinguished from select move?
Yes.
And therefore, if we don't allow your appeal on this point, we would have to overrule select move?
Yes. And the reasons I say that is that, and please, if it's not of assistance, but although this was a revenue case, where the arrears are owed to the revenue, you will see there that the argument that was made, and this is at page 309 of the electronic copy, or 109 of the paper copy, was not only to pay off the arrears, but also to meet future tax liabilities as they fall due. So it is hard to think of a more continuing relationship than that between a taxpayer and the revenue. If you're going to base it, which is one of the distinctions...
It's not one that could quite so easily be put to an end as a licence.
But it isn't in Lord Justice Russell's judgment, I think, in Williams and Roffey, he talks about the continuing relationship. And I submit that's not core to the ratio of the decision, and wasn't regarded as core to the ratio of the decision by Lady Justice Arden, as reflected in her remarks in Collier. But there was, if the circumstances in practical benefit will apply, our continuing relationship, then there is a continuing relationship in reselect move. Curiously enough, there's no continuing relationship in our case, because there was an obligation to pay rent until the 1st of November of 2012. And there was an obligation to pay the arrears. Nothing beyond that was agreed. And in relation to the agreement to pay under the license agreement, that wasn't the subject of the oral variation. The oral variation only dealt with how we pay the arrears. So, my lords, I draw your attention to that, and really, I'm afraid it's been wrongly attributed to Lord Justice Balcombe in parts of our statement of case, which we apologise. But you have, I think it is page 311 of the electronic copy, this passage in the judgment of Lord Justice Peter Gibson, with the extensions of Williams and Roffey.
If Williams and Rothie is to be extended to an obligation to make payment, it would in effect leave the principal in Folkes and Beer without any application.
Yes.
Were we asked to convene a 7-judge court?
No, my lady. And the statement of issues does not include a argument that you should, in effect, go down the route suggested by, that you would have to go down, suggested by Lord Justice Peter Gibson. It's not in the list of issues.
Well,
But in a way, you're saying it should have been.
No, my lady, I'm saying that it would have to be. I'm doing what I'm no doubt appellant counsel always doing. I contend that if you attempt to do this by what I submit as the back door, you will cause serious mischief. You will have a series of cases as to what is and isn't practical consideration. And it will depend on the judge. I'm submitting you can distinguish between the two cases because one is about the payment of money, and I'm submitting that that distinction goes right back to Pinnell's case, and that although Stilk and Myrick, which was the Siemens case about the performance of the obligations I know the court will be familiar with, although they are comparable in many ways, the arithmetic point is present in Pinnell's in the way that it is not present in Williams and Rothie.
I mean, one difference here is that the sum of money, I think we're told, payable over the period was the same. It was essentially the stages at which it was arrived at, so that the mathematical point doesn't arise, at least not in quite the same way. I mean, if you rescheduled payments so as to make them earlier, there would clearly be good consideration.
Yes.
But your submission is that if you reschedule payments so as to make them later, there isn't.
Yes. Because of the, I'm trying to, I hope we'll alight upon the quotation from Lady Justice Arden, which is either in MWB or in Collier, about the delay in payment must be worth less.
Yes. Still seems an odd result.
You say curable by the addition of a peppercorn.
It is curable, yes, and although...
or doing it by deed.
Or doing it by deed, but if I understand that, and I was intended to show that my position is absurd. I say there's no absurdity in that. There's no absurdity in it in principle, because the peppercorn overcomes the arithmetical problem. There's no absurdity to it in practice, because by the peppercorn you are evidencing the intention. And I don't say the only purpose of consideration is to establish intention, but it is one of the purposes. And if the parties themselves are recognizing by the peppercorn they intend to be bound, then, as I say, they have fulfilled the purpose which Professor Attia has suggested is the function of consideration. So it isn't if I could, though, remind you in relation to, because I'm not sure that I necessarily did it, just I note the time and I will finish, of course, but in relation to Williams and Rothie, I've referred, but not actually taken you to the points. I don't think I have, if I might, just as to the fact that certainly in Williams and Rothie, they did not regard themselves as doing away with consideration. And that is, of course, tab 12 in the core bundle, the authorities bundle 1. It starts at page 379. If I could just remind your lordships of certain parts of it, which is that at page 185, 395 of the electronic bundle, Lord Justice Glidewell was very keen to observe between letters B and C that his propositions, the 5 that I've found, do not contravene the principle in Stilk and Myrick. So he was intending to preserve it. And if one then goes on to the speech, to the judgment of Lord Justice Purchase, which is at page 399 of the electronic copy and page 189 of the paper copy, and look at letter F, where Lord Justice Purchase states, "I would not be prepared to overrule 2 cases of such veneration involving judgments of judges of such distinction, except on the strongest possible grounds, since they form a pillarstone of the law of contract." And of course, as your lordships will have seen, in select move, well, Justice Peter Gibson indicates that the preferable way to go, if you are going to remove the requirement for consideration, is by Parliament. So, our argument is the law on consideration as it stood before this appeal was heard was one which, as your ladyship has observed, or not accepted but observed, we say falls within reselect move. You can see that. It is a payment of money. It is nothing else. This court should not seek to reform the law of consideration, because, as I began at the outset of my submissions, it is more than simply knocking away that requirement. Professor Attia says you're then left with the question, what do you put in its place? And you have to consider, when you look at other jurisdictions where they don't have consideration, to look at the whole of their law of contract. Which promises they choose to enforce. Because
well, we wouldn't actually have to to abolish the law of consideration. What we would have to do is to say that practical benefit, albeit not reflected in the actual nature of the obligation, was sufficient consideration. That's not abolishing the consideration doctrine. It is simply accepting something as consideration, which I agree the House of Lords appears not to have accepted as consideration in Folks and Beer, because the point made a few minutes ago by my Lord Briggs was exactly the point made in his effectively dissenting speech by Lord Blackburn.
Well, my lords, Lord Blackburn didn't dissent.
No.
He lined up with their other lordships, and he did so, in my submission, because of the body of authority that had followed that position.
He said he would follow authority, but he recognised the unsatisfactory consequences of doing so at page 622, towards the bottom of the page.
Yes, my lords, but it's that body of authority, referred to by one academic as ossification, but that process has continued. It has become a pillarstone. And for the reasons which I don't think I can better than as they're set out by Lord Justice Peter Gibson in Reselect Move, there will always be a commercial benefit. You do, therefore, do away with the requirement for consideration. What is to distinguish this case from Reselect Move? And when would the law of consideration apply if, in the context of variations, it could be found to be satisfied from the fact that the parties have perceived a benefit from making that agreement. When would one need consideration? And that's why one then goes to say, so what requirement does one put in place to recognise, to have this process of recognition of obligations the court will recognise and enforce and obligations that they won't? So, the one thing I'm certain of is repetition won't improve the arguments. There is, what I'm saying in relation to consideration, a stark but honest choice. You haven't actually come here to say do away with the rule in Vokes and Beer. But I submit that on the facts actually found, that is what you would do, and you would do it by the back door, and you would do it by what is in effect a fiction of saying practical benefit, because you would imply it in circumstances which go way beyond Williams and Roffey. And I'm not suggesting there won't be cases where there could be a practical benefit, but you will leave the law of consideration at naught. So,
is there academic commentary on the Court of Appeal's decision on this point, making the same point that you're making?
Roberts, really, isn't it?
I think, yes. I think it is Roberts, yes.
Morgan?
On the consideration point, it's Roberts, isn't it? The academic consideration of... yeah.
We looked at Roberts in relation
Yes.
to the anti-oral variation clause.
I mean, Roberts makes the point that the Court of Appeal's decision can't be reconciled with Vokes and Beer. It's page 779 in the hard copy numbering. Flag 35, volume 4.
Sorry. All right. Thank you.
Sorry, what page reference?
Well, my lord, my lady, I think it's page 779 is where we were taken to, which is authorities bundle.
2002, isn't it?
2002.
Oh, I'm sorry, I've...
Yes, well, I can see that he says it has its problems, but
Yes, well, my lady, my lordships, I mean, there it is. There is a commentary to add. Could I just, because I make the comment in relation to page 1004 of the electronic 781, that I do draw a distinction, because I think Lady Justice Arden talked about the modern equivalent of the robe, horse or a hawk. This is, and I think Lady Justice Arden acknowledged that, a peppercorn, if you like, that's being provided by the courts and not by the parties. And I do think that's an important distinction. One last matter I did in relation to the value of money. It was in MWB, and it was, paragraph 82 of the judgment of Lady Justice Arden, which is at page 338 of the electronic copies or 138 of the paper copies. The argument for MWB amounts to this: the variation agreement was a promise to pay a smaller amount than originally agreed, in that the time value of money has the effect that an agreement to defer payment of a due debt is in effect an agreement to pay a smaller sum. Obviously, we adopt that. So, my lady, my lords, I note the time. If I've missed any points of any value in or we've missed in our statement of case, I hope you will take them into account. And obviously, we will reply to those points later in this hearing, and indeed address my Lord Sumption's request in relation to entire agreement clauses.
yes, well, there's quite a lot of material on entire agreements.
I think we were asked
in the
to find...
article which we
Yes.
were referred to.
I think we were asked to see if we could find anything extra. So it's only in that regard we will return to it.
I mean, we can easily lay hands on the references in the article. It's just if there's anything else.
Well, they're all High Court cases. Nothing referred to in the article is above the High Court. Lots of High Court cases, but very well. We will adjourn now and look forward. Miss Blackburn, do you wish to follow?
It's Miss Blackmore, actually.
Oh, Blackmore. Sorry, I was misreading at a distance. I'm so sorry.
I've nothing to add. Thank you.
Thank you very much. Yes. Well, we look forward to hearing from you, Mr. Paget, at 2:00.